Hi, everyone. We're going to be presenting today on the topic H-1B fiscal year 2020, pre-registration, hot topics, and overcoming restrictive adjudication standards. So I just wanted to give everyone kind of an overview of what we're going to be covering today. We're going to do a quick basics H-1B overview, and then I'll be talking about the new electronic pre-registration system. And then some hot topics like STEM OPT planning, the increase in government filing fees, and H-1B audits. Jennie will be discussing overcoming restrictive adjudication standards, which is basically requests for evidence. And then we'll have a Q&A session at the very end. If you have any questions, you can go ahead and just type it in the questions box. We may not be able to get to all of them, but we will reserve some time for some questions. Any of the resources we have, and if you want any updates about immigration law, we welcome you to subscribe or check our website at woolstorf.com. And this webinar will also be available on our YouTube channel. So let's get started. So the basics of an H-1B, I think many of you know that it's a professional work visa. And the requirement is simply, well, not simply, but they have to have a degree. The individual has to have a degree or its equivalent, and the position itself has to require a degree. So we give some examples of some job titles or job descriptions that we've seen for H-1B and that we've handled. The other important thing to note is it is employer specific. So if you have an ABC employer, the employee must have an H-1B for that specific employer and cannot work for any other employer. It can be part-time or full-time, so you can have an H-1B sponsored for part-time work. It just has to be noted on the petition. There is a 6-year maximum, meaning that you can only be on H-1B for 6 years total. It can be split up in many different ways, depending upon how often the employee changes employers, and it's granted in 3-year increments. When you hit a certain milestone in the green card process, which we're not going to cover today, but just for basic understanding, you can renew the H-1B past the 6-year mark, and that's if you have a perm filed for the employee a year ago, or an I-140 is approved and they're just waiting for their prior date to become current. So the other item I want to talk about is portability. So you can transfer an H-1B employee to another company at any time. They're not subject to the H-1B cap. They've already been counted as part of the H-1B cap. So none of the H-1B registration or cap information will apply to anyone who's already currently holding an H-1. There is currently an EAD, a work permit, available for H-4 dependents if the principal has an approved I-140 and the prior date is not current. But note that may be eliminated sometime this year. We're not really sure when. So we recommend that anyone who has an employee who's on an H-4 EAD, that they renew the EAD as soon as you can. You can renew it 6 months prior, and also think about putting them into the H-1B cap. So another part of the H-1B process is what we call a labor condition application. And this is submitted with the Department of Labor. And in this application, the employer has to attest that it will pay the higher of the prevailing wage or the actual wage. So how do we determine the prevailing wage? The prevailing wage is determined by the Department of Labor or a wage source that the DOL has routinely accepted. And we give you the link to the prevailing wage site there, flcdatacenter.com. And the actual wage is a wage that you are paying your similarly situated workers. So if you have 5 software engineers in the same role, the expectation is that you will be paying that software engineer the same wage that you're paying the others. So that H-1B sponsored employee will be paid the same actual wage. So you have to pay the actual wage if it's more than the prevailing wage. So let me just give you an example. Let's say you have a prevailing wage for a software engineer That's at $100,000 a year. And then you have a team of software engineers that are being paid $120,000 a year. You are required to pay the H-1B worker at least $120,000 per year. And you have to ensure that you're giving them the same working conditions as you give to other US workers. I get a lot of questions about whether you can count bonuses in the wage to meet the prevailing wage or the actual wage, and the answer is no. It has to be a guaranteed bonus. So it can't be one that's based on performance. It has to be guaranteed amount. When we prepare the LCA, we will send it to the company, and it will need to be posted. And so the notice will be posted in two places. And once you have posted the notice at your work site or where the work will be conducted, then we will submit the LCA to the Department of Labor. So Department of Labor currently takes 7 calendar days to process the LCA. I just want to let you know that during H-1B cap season, when there's a flood of applications, we tend to see longer time periods, and sometimes the system is unavailable for a few days. So just so everyone understands that. For an LCA, you can only request a start date from 6 months out. So, you know, for many of the H-1Bs, if you're going to wait to file until April 1, your start date then can be 10/1. But many times for all of our H-1s, we actually move the start date up so that we actually can file the petition sooner rather than later. So this is the H-1B quota, and this is what we call the cap. So the fiscal year runs October 1 to September 30. When I first started practicing many years ago, over 20 years ago, there was no H-1B cap that was ever met. And during the boom years, we would see that the cap was met. And what is the cap, right? So the H-1B cap is for private employers only. If you are a educational institution, a post-secondary like university, a nonprofit research organization, you don't need to worry about the cap. You can file H-1B petitions at any time. So if you're a private employer and you don't meet any of those exceptions, then you will, the individual will be subject to the numerical cap. So there's 65,000 numbers available per fiscal year. That's for anyone from any country, 65,000. There are reserved 5,400 for those from Singapore, and then 1,400 from Chile. Singapore and Chile's cap has never been reached. They also have an additional 20,000 for US graduates with a master's degree or higher. And so that's a special reserve pool of numbers that are reserved specifically for these individuals. So just last year, the USCIS received over 201,000 petitions. That's pretty typical, and I think that may be the highest I've seen since I've been practicing. So the big question now is, what is the timeline for the H-1B cap, given this change in registration? And we just came up with a rough timeline for everyone so you can view it. So from December 2019 to February 2020, you want to be sure that you're initiating the H-1B sponsorship process, which means that you have engaged our firm, talked to us, told us about the interest in sponsoring someone for an H-1B. Starting on Sunday, March 1 to Friday, March 20, that is when we can start registering the sponsored individuals into the My USCIS account. Once the registration period closes on March 20th, the USCIS will then conduct a lottery for the available slots based on the number of registrants it received. Once they conduct the lottery, then there's a 90-day filing window that opens. So only those who have been notified that they have been selected will be able to submit an H-1B petition. So we expect that the H-1B filing window will open sometime on or after April 1, because the earliest start date for an H-1B is 10/1, and you can only file an H-1B 6 months prior to the start date. So that's our expectation. When it will open after April 1, we don't know. We're waiting for guidance from USCIS, and they said they will publish it once they provide that 90-day filing window period. And then on or after October 1, 2020, the H-1Bs will be approved. Well, they're typically approved, right now, regular processing time for H-1B is over 9 months. So if you submit the petition within that 90-day window, and there is no premium processing is where you pay the government an extra $1,440, and they will process the case in 15 calendar days. Last year, they did not allow premium processing, and then they opened premium processing later on. So we have seen H-1B cases that have been pending for over 9 months that we filed in April of 2019. So the H-1B is effective on 10/1/2020 and thereafter. So this is the fun stuff. This is the pre-registration process that we're all have a lot of questions about, and I'm sure that's why you signed up for this webinar. So let me just caveat everything by, this is a new process. There was a proposal back in 2011 about moving the USCIS to a registration mode. And it took the USCIS 9 years to finally implement it. So the final rule was last year in April of 2019, but they didn't have time to implement it. So they're implementing it in 2021. So that basically means that it's going to be implemented this coming March 2020, and this H-1B cap year. So the new selection process, what can we expect? It's an electronic registration submission. So employers, attorneys, if you're going to submit a registration, it has to be done on the USCIS portal, myuscis.gov. Once you submit the registration, you also must pay a fee, and there's a specific portal where the fee must be paid. So it's pay.gov, and they will only accept ACH, so bank payment, credit card, or debit card. So they are not accepting any written checks. Everything is done through the portal. You can batch payments. So if you have a number of employees that you want to register for your company, then the payments can be batched. The number one thing you need to know, like all other H-1B fees, it must be paid by the employer. So even the $10 fee payment must be paid by the employer. So what happens once you register? So within that March 1 to March 20 time period, we as a firm will create an account, enter the information. I'm going to go through the information, and then once we submit the registration, there will be a confirmation in the portal. So everything is trying to be directed into the portal. We don't know if they're going to be emails sent to attorneys, employers about the registration. I really think they're trying to move everything into this myuscis.gov. And then once they conduct the lottery, which I'll explain how they're going to conduct the lottery. So historically, the lottery has been done where they will first conduct the lottery for the U.S. master's degree holders. So remember I said there's 20,000 H-1B numbers reserved for U.S. master's degree holders. And then those that were not selected will then be put into the pool of the remaining 65,000, which is open to everyone. There is a reverse lottery order that's going to happen this year. So what will happen is that everyone will be put into the 65,000 pool. So all applicants will be put in there. And then any U.S. master's degree holders who were not selected will have the ability to be placed in the 20,000 pool that's specifically geared for them. So this is a reverse lottery order, and the intention really is to increase the number of U.S. master's degree holders obtaining an H-1B number. Okay, so once they conduct the lottery, notification that the person was selected will be available in the portal. In the portal as well, there will also be a notice that needs to be printed and submitted with the USCIS H-1B petition filing, confirming that they were selected under the lottery. Now, people are asking, and the USCIS has stated that they also will create a wait list. So what does that mean? So that means that folks who were not picked, they are going to create a reserve. So they'll basically see if they have enough numbers to fill the 65,000 and the 20,000, and then they will start taking folks from that pool that had won the lottery in that specific order. And so that means that anytime during the period after the lottery is conducted, we would still be checking the portal to see if someone else may have been picked. The big question is, will you know if you are not picked, right? Because that has been the biggest question before. We used to know you were not selected, the employee was not selected when we'd get a return petition. That's all unknown. You know, we know that on the portal, you'll know if you were selected, but we don't know, you know, how it's going to play out in terms of whether you'll know you're not selected, you know, by the employer logging into the portal or the attorney logging into the portal. If they don't have enough registrations, they'll reopen the registration, which I highly doubt. I think they're going to get lots of registrations. They can't, so the USCIS has stated that they will provide trainings and guidance on how to use the registration system. The registration system can be canceled if the entire system is inoperable. So I'm just going to give you some history of what we've experienced whenever the government has introduced new technology. And usually there are crashes, usually there are unexpected usage, and then the system is down. I'll just give you an example. Most recently for DOL, they have a new system where people register online for H-2A, H-2B, and they had over 100,000 registrants. And, you know, the system, we don't know what's going to happen, so we just have to wait and see. So what is required to register? So the more important thing you need to know is that it's just this type of information. So the registrant information, so this is the company that's registering the individual. What is the company's legal name? What is the company's employer identification number? What is your address, the primary US address, and the legal name, title, and contact info of the authorized signatory. And then the information about the person that you want to register under the H-1B. So that would be what we call the beneficiary. So their legal name, their gender, education. So do they have a U.S. master's degree or higher? The date of birth, the country of birth, country of citizenship, and their passport number. So you'll notice that when you register, there's no information being asked about the offered position, like the job title, the minimum requirements, or job description, okay? So this is the information that they're going to request to conduct the registration. One of the biggest questions that folks have is, do you have to have the master's degree at the time of registration or at the time you submit the H-1B petition? There's no guidance on that yet. But to play it safe, I would say you want to make sure that the employees have the U.S. master's degree at the time of registration until we get guidance. So here are some pointers that we wanted to talk about for registration. The number one thing everyone needs to know is that submitting a registration does not maintain anyone's status. So if you have someone that is expiring in March when you submit the registration, it does not mean they can stay, okay? So that's really important to note. H-1B registration is just a tool to advise the government and do a lottery system, but it's not a means to maintain any immigration status. So I mentioned before that you don't need to establish eligibility to register, right? So you don't have to give the job title, the job description, but you do have to provide eligibility when you file the actual petition with the USCIS. So again, it's unclear how they're going to apply it to the U.S. master's degree exception. If you have to have the actual master's degree at the time that you register, you know, some of the questions we've seen put it in present tense, meaning at the time you register, do they have a U.S. master's degree? So we're not sure about that, but look out on our blogs and information, and we'll provide guidance on that. The other thing is what a lot of people are concerned about is how do they know it's a bona fide and non-frivolous case, right? And so what we are advising is that it's extremely important to have WR assess and evaluate the petition, the position, the credentials of the beneficiary prior to submitting an electronic registration. It is important that when you submit the registration, you already know that the individual you're submitting the registration for will meet the qualifications and requirements of the H-1B, right? So that means that do they have a degree that's related to the field of study and the position being offered. We talked about the LCA. So the LCA is not required to be completed before you submit a registration. But here at WR, we want to prepare the LCAs in advance of electronic registration. Why is that? Because we know that there's a 90-day window to file. We don't know when it will be, but we know many of our clients and many of the employees will want to be the first ones there who submit their petition, or it's submitted shortly thereafter once we know that the filing window has opened. And like I said, LCAs can take a longer time period, can crash, the system can crash. And so we at WR just want to be prepared as much as we can so that we can ensure that the petition is submitted timely. So WR will register employers and beneficiaries, and we're going to submit a G20H which notifies the government that we are the attorney of record. And we are going to pay the registration fee on behalf of the employer, the $10 registration fee, but that doesn't mean that we're doing it, the $10 will still have to be reimbursed by the employer to WR. And so what happens when you submit the registration and then you get notified that you have been, the individual has been selected when you look on the portal? Right now, the USCIS is working in a first in, first out system during the 90-day window. So what does that mean? That means that if you submit your petition on the first date that the window opens, then your case is in line, in queue to be processed by an adjudicator. We don't know whether premium processing will be available. Again, premium processing, you pay an extra $14.40 and your case gets processed in 15 calendar days. So what we're advising clients is it's important to know which employees need to be ready to file the minute the window opens. And what we're telling employers is if you know that someone's OPT is going to expire before October 1 and it's not renewable or extendable, it is important that you file that case as soon as possible. The reason being, if there is no premium processing and you file the H-1B petition on the first day that the window opens, the 90-day window opens, like I said before, USCIS can take more than 9 months to process an H-1B. And for F1 students, which I'm going to go through in a bit, they actually, if they are here in the US and their OPT expires before 10/1/2020, they will not be able to work after 10/1/2020 without an approved H-1B petition. So what do we also know about registration? So some of the things we know is you can submit a registration. You can enter a registration and you can edit it prior to hitting that submit key. But once the registration is submitted, you can't change it any longer. You can't edit the entry. So it's really unknown how USCIS will handle typos, delete and resubmitting. And then how can you contact USCIS during that limited March 1 to March 20 period when you're submitting registrations? Now, the most important thing to note is that you can only submit one registration per beneficiary. So ABC Company can only submit one registration for Amy Smith, right? So if they find that there are duplicate registrations, all the registrations will be canceled for Amy Smith, right? So what is our biggest concern? Our biggest concern is the technology in the system. And if there are glitches or errors and you thought you submitted the case, but maybe you didn't, then you submit it again. And then you're trying to contact USCIS between March 1 to March 20th, nobody's responding to you. And then the window closes, and then you find out the registrations were all canceled. So those are a lot of our concerns as to how this is actually going to play out. And I was joking around with one of my clients, and I told them that, yes, you probably want us to do the registration because I'll be the one who's up at midnight trying to get your case registered. So just one of the concerns that we all have about registration. The other thing you need to know is there's no substitutions allowed. So if that employee, Amy Smith, decides she doesn't want to join ABC Company, you can't simply just replace that registration with another employee. This is another question I get a lot. Like, if a company has multiple entities, so if you have ABC Company with a different employer ID number, and then you have a sister company, XYZ Company, can both companies submit a registration? Well, theoretically you can, but you have to be really careful because they don't want companies with many different entities in the US to game the system, meaning that you're just submitting registrations and hoping that one company will, win the registration for that particular employee. There has to be a legitimate business need and a real and separate job opportunity. So I have seen decisions where they actually will revoke the petition or deny the petition when they see that there were two H-1B petitions filed for the same person. In registration, same thing, you could register them, but then once it gets to adjudication, it probably will not be approved if they see that you're offering the same software engineering job to the same person, but just two different related entities. Again, notification of selection, we believe, will be made via the online portal. You log in, and then we'll be able to see who was actually selected. Now, the biggest question is, fraud. And how are they going to prevent it? Well, the USCIS says in many of their literature that they handed out, or just information that we've read, that there is going to be an attestation when you register that there is a bona fide job offer and there is an intention to file an H-1B petition. So if there's a reason why an employer can't file the H-1B petition, even though they received a selection notice, as long as there's a legitimate reason why it wasn't filed, maybe the individual decided they weren't going to stay in the US and went back home, then that's fine. But if they see a pattern of an employer filing a large number of registrations and then there's not the same number of submissions for those that were selected and notified, they will be investigated. And the USCIS will refer anything to law enforcement agencies There will be monetary fines and penalties, making false statements and misrepresentation. So just for an example, you have Amy Smith. Amy Smith isn't available, so you bring in a second Amy Smith, someone else, someone whose identity they'll have to verify, things like that. They've thought about things like that in terms of how to prevent fraud. They also will produce reports to determine how many duplicate petitioners and beneficiaries are actually registered in the system. So a lot of questions being asked about how does this play out for an H-1B, the cap gap for our F1 students. And so this is just an example to give you some clarification. So let's say the student graduates on June 2019. The optional practical training, which is the 1 year of work authorization they get upon graduation, starts on July 2019. We register that employee in March 2020, and then if we know that they're selected, we file the H-1B before the OPT expires. So within the 90-day window, we would want to file it before July 2019, okay? Once we file it, the OPT ends, and then there's a period called the cap gap, where the employee is able to continue working until September 30th, 2020, because the goal is to have the H-1B take over on 10/1/2020. If the H-1B is not approved by 10/1/2020, the employee can stay in the country, but unfortunately, they have to stop working. Okay, so that's a very important distinction to make. So cap gap is only available upon filing the H-1B petition. So even if you submit the electronic registration in March, right, and then you get notified, and then you submit it in April or May, if their OPT expires, you know, before the period or the window that you can actually submit it, they are not going to get cap gap. So they are not going to have the ability to work. So if the OPT expires after the H-1B is filed, then they get the cap gap relief, only until September 30th. So again, if the OPT expires before the H-1B filing window, they have to stop working, but they can stay in the country as long as the H-1B is filed within their 60-day grace period. So as long as they're maintaining status, they could stay in the U.S. until the H-1B is approved, and they're going to stay authorized by the Attorney General, and they can stay in the U.S. even after the 60-day grace period. I know it's confusing, so just ask WR for guidance, and we're more than happy to provide guidance. So what does this do? This actually gives individuals the ability to plan better. Historically, we didn't know whether a person was selected or not until much later in the year, like the end of the summer or the fall. But now with notification selection, perhaps we'll know sooner, and then the students can plan and they can look at re-enrolling in school, moving to another status, or departing before their grace period ends. So the other hot topic too is they're trying to increase the fees. Yep, so for the H-1B, it could be in effect as early as March 2020. They're going to increase it by $100. So it goes from $460 to $560, and these are just the mandatory fees that are required for an H-1B and the optional premium processing. So H-1B audits and random site visits, this slide just talks about what you can expect. Employers pay a $500 fraud fee, and the fraud fee is used to fund the site visits and audits. And what DHS does is they will randomly show up at the company unannounced and ask to interview the individual who is working on the H-1. So number one tip for companies, always make sure your reception or security has been trained and knows how to follow procedure and who to contact. You don't want the employee to be sitting with the officer without an HR or another person present. They will tour the location and take pictures and ask to see the workstation. So if the employee changes job title, job location, or anything changes in the job that's material, a 50% change or more, you should notify us so that we can advise you if there needs to be an amended H-1B filed. Buy American, Hire American, BAHA. I think a lot of people know and understand that the reason why there's so many changes these past few years and adjudication standards are higher, which Jennie's going to go through, is because of this executive order called BAHA. And really the goal behind BAHA is to just, you know, increase the scrutiny, which is what I think they're doing, increase the scrutiny and really advance policies to ensure that H-1B visas are awarded to most skilled or highest paid beneficiaries. That's the reason why they switched the lottery. You know, it's a reverse lottery. U.S. master's degree holders are able to have a higher chance of being selected because the USCIS feels they are they're more skilled, and at the end of the day may even be paid higher than another worker. So these are just information about, you know, some of the initiatives behind BAHA that we're seeing. And now I'm going to pass it off to Jennie, and she's going to talk about the H-1B visas and how we're seeing it being adjudicated differently under BAHA.
Thanks, Charina. Hi, everyone. I'm just going to go through some of the broad trends that we see and a little bit of the specifics for some job titles and some SOC codes that are receiving even greater scrutiny than they have in the past. And if you have any questions, you can feel free to type them into the chat box or the question box, and we'll try to get to as many as we can. So as Charina said, as a result of BAHA, it's getting much tougher now to have an H-1B visa approved. So some alarming statistics are that 60% of H-1B cases receive an RFE. That's extremely high. And 40% of those after that are getting denied. So that means 24% overall of cases get an RFE and are ultimately denied. WR has a really high approval rate, but we definitely do field a lot of RFEs before we get to the approval. So on the next slide, you'll see some of the, Charina, can you, yeah, thanks. You'll see some of the main areas that CIS focuses on in issuing RFEs. The biggest one is the specialty occupation. So the H-1B requires that the position is a specialty occupation, which means that it has as a minimum entry to that position, you have to have a bachelor's degree in a specific specialty area. So most of the time, the RFE is issued because CIS says the job description is not sufficiently detailed, or it doesn't correspond with the correct SOC code, or the degree is not sufficiently related to the position. So when you're drafting the H-1Bs, you want to make sure that you've covered all of those bases. And if you do receive an RFE, there are 4 different alternate ways to establish the specialty occupation, which I won't go into in this talk because it would be too long. But the main thing, I think, is to try to draft the initial petition such that you avoid the RFE in the first place. Because once you get the specialty occupation RFE, it's a pretty lengthy one to respond to. So another type of RFE is the employer-employee relationship. So this one and the one after that, and the availability of offsite work, these are mostly for H-1Bs that deal with remote worksite locations where a client is placed off-site. And so for those types of petitions, I'm sure practitioners who do these are aware you have to have additional documentation to establish that the employer has the right to control the employee's work and that there is available off-site work throughout the duration of the H-1B requested period. And another RFE we've seen is maintenance status. So they sometimes question whether an F1 student did not have more than the 90 days of unemployment during the OPT period. And of course, when we file change of status, we always include maintenance of status documents, but they even sometimes go back to previous periods of OPT to ensure that there was no violation of OPT requirements during that time. So the next slide talks about the availability of work in-house. This is something that they pair with the employer-employee relationship RFE, and it happens often for smaller companies and startup companies where they don't believe that the employer is going to have sufficient work throughout the 3-year period that's requested. Another type is the LCA. They sometimes question whether the LCA is the right category for the job. So I'll get into this a little bit later, but selecting the right SOC code is kind of like this new art now, with a lot of different factors to consider. And you have to make sure that everything on the LCA corresponds with the petition, and also that the SOC code that you've chosen really matches the position and the beneficiary's qualifications. And also there's concerns about level 1 prevailing wages. There's talk about whether level 1 positions really are specialty occupations, which we believe they are, and for the time being they are, but that's another type of RFE that we see. And the last bullet here we have is the itinerary for multiple work locations, and this again goes back to people who have remote work sites, or if the employer is in multiple work sites. And so you just have to document with statements of work and contracts and service agreements that there is work available in those locations. Okay, so we're going to move on to some RFE trends. So to get into more specifics, these are some of the job titles that we're seeing that are being issued RFEs as a matter of course. And these are more tech focused. A lot of our clients are tech companies, but they're software quality assurance engineers and business intelligence analysts, product managers, and data scientists. And these are often because there isn't a perfect SOC code to go with each of these job titles. For the first two, those actually fall under a subcategory of computer occupations all other. And as you'll see in the next section, computer occupations all other is basically an SOC code that's almost guaranteed an RFE, I would say. Product managers and data scientists, these are sort of new types of positions that the DOL hasn't really accounted for in sort of a new job market paradigm, and they're more interdisciplinary. So usually that's going to require case-by-case analysis to determine, you know, which SOC code best fits that particular product manager or data scientist role. So moving down to the middle section, corresponding to the job titles that are commonly issued RFEs are some SOC codes that we like to avoid if possible, but sometimes we can't because there just really isn't a better option. So I discussed computer occupations all other. So USCIS basically just says that it's too broad. There isn't any specific information in OOH about computer occupations all other, so they just issue an RFE. It's definitely surmountable, but it takes a lot of additional documentation to get that petition approved. Operations research analyst, this is another one that commonly gets an RFE, and it's because the OOH says that there are different types of degrees that are sufficient for it. Actually, I think it's a pretty good job code if you can document exactly why the person is an operations research analyst, because it often is an occupation that requires a master's degree. The other one that is often RFE'd is computer systems analyst. I think that this sometimes is chosen because there might be a wage challenge for other types of engineering or software development positions or SOC codes, but it's a really challenging one to overcome. I think it's possible, but I think that an RFE is very common for this because the ONET shows that only 47% of individuals in this occupation have a bachelor's, and the OOH specifically says that you could have a liberal arts degree and have sufficient training and still become a computer systems analyst. So USCIS really focuses on the language in the OOH. Another category historically is marketing types of positions, again, because of the variety of degrees that are possible to prepare one for this position. And then managerial positions, even computer and information systems managers. And that may come as a surprise, but what you need to do for those types of positions is establish that the individual isn't just using managerial soft skills, but actually requires the underlying engineering or technology knowledge in order to perform the job. A few other trends that we're seeing is that sometimes we're seeing RFEs now for codes that we used to consider quote unquote safe codes, like software developers, applications, or software developer systems. They're basically saying that not everyone who's a software developer is an H-1B specialty occupation. So you have to do a little bit more now to ensure that even a software engineer is going to be able to have that H-1B approved without an RFE. Same as historically, marketing and finance positions are still difficult to obtain approval without an RFE. And now also part of BAHA, there's no deference given to any prior adjudications. So even if you had an approval before and you're extending and nothing is different, you can still get an RFE for that, that extension petition. So next slide just has some pointers, corresponds to what we've talked about already, which is that in preparation, I think as a matter of course, it makes sense to have more detailed job descriptions than you might be used to preparing or seeing. It used to be we would file an H-1B with a very cursory job description and that would be approved. But now USCIS will issue an RFE asking for a more detailed job description. So I think best practice is to add as much detail as possible and also to make sure that your tasks align with what the OOH says for what that occupation does. Another thing is I think it is helpful to include the specific specialized knowledge coursework and how that is needed in order to perform the job duties, and to list out that coursework in the sections of the letters of support that talk about the beneficiary's qualifications. And then finally, I think the best way to avoid an RFE, if it even is avoidable and it's not avoidable in every case, is the selection of the SOC code. And this is really a critical part of the H-1B preparation process, where some cases it's very straightforward. It's a software engineer, they have a CS degree, the wage is sufficient, everything looks great. But oftentimes, it's something in between, like it's a product manager and the person has a marketing degree and maybe like a data analytics degree. So then you need to do a really careful analysis of the job description, the job title. So sometimes the title can throw CIS off, and so you have to work together, the attorney and the HR, to see if there's any flexibility in job title, and then the beneficiary's educational background, and figure out through that sort of matrix what's the best SOC code. So a few SOC codes that are not as common but I found to be useful and that you can consider are computer and information research scientist, for anybody who has a graduate degree and it's some sort of computer related position. Sales engineer, which might be possible for some marketing positions if they're really doing sales. And then you can also try the underlying engineering code if the person has an engineering degree. Computer hardware engineers for somebody who's working in infrastructure systems, because in some MSAs, the wage is a little bit lower. And then statistician, which we've used for data scientist positions, if the person has like a math or stats degree, or sometimes we see data analytics types of degrees as well. And then the last page is just a few other pointers for avoiding other types of RFEs. Level 1 wage is receiving a lot of increased scrutiny. So you just need to really tie in the degree with the position and argue why the position really requires that specific specialty type of degree. I would definitely put in specific coursework and consider a detailed job chart. Another thing about level 1 is that it has to make sense to USCIS. So if it's somebody who's just graduating and is coming from OPT, then that makes sense for someone to be in level 1. But if it's somebody who has several years of experience or is already here on an L1 as a transfer, then USCIS is going to be very suspicious why you're applying for an H-1B for a level 1 position for that employee. Again, as part of BAHA and even before that, new companies that are less than 10 years old or small companies that are less than 25 employees, I think it's a good idea to add in extra documentation of the company's active business presence and ongoing business, or you can receive an RFE on that. And then just remote multiple work site reminder to include the additional documentation about the relationship, like offer letters, performance reviews, pay stubs, to show you control the employee's work and that there's sufficient in-house employment throughout the duration of the requested H-1B period.
Okay. Anything else, Jenny? All right.
No, I think that's
so,
it.
All right, so we have some questions. Just gonna go through them and see if we can answer some of them. Jenny, have you seen any that you think you would be able to answer?
You know, I don't see that many. I don't know how many you see.
Okay, I'll answer the first one. Is registration requirement for H-1 sponsors which are eligible for non-quota treatment? Again, the H-1B registration requirement is only for those subject to the numerical cap. So if your employer or the company sponsoring the H-1B is a university, nonprofit research organization, and not subject to the cap, you do not need to follow this registration process. So questions about if you are working for a cap exempt employer and now you want to change employers to a private employer, you will be subject to the registration requirement because you are obtaining an H-1B that's subject to the numerical cap because your prior H-1B was not. So you would need to follow the same process of registering and then seeing if you were selected. And then another question was, do you need to mention client details for electronic registration? The slide that I showed to you shows the basic information that they want about the employer, like the FEIN, address, those types of things, who's going to sign. And then, let's see, any other questions? There was a question about, do you recommend filing the LCAs in February or March or after registration? I recommend filing the LCAs as soon as you can. So our office is already preparing LCAs because we want to be ready and prepared. You never know, maybe the USCIS, the system is inoperable and they revert back to the old system. We don't know. And so we just want to be prepared here at WR and do what we can for our clients to ensure that we can submit the petitions timely. Let me see, any other questions?
There's an RFE question about system administrator position and SEC code as computer network architect. I think the best option when you get these challenging the degrees is to go to a trusted evaluation agency. Like we use Trustport or Silvergate and present to them the RFE and the supporting documents, and they can provide a professor-based evaluation for your purposes.
Yeah. Another question is, if you have individuals that will not be starting with your company until after the registration period, but you know they will be joining you in the fall, and they already have at a minimum a bachelor's degree or even a master's degree, should you submit their registration and plan to file their H-1B? Yes. So the biggest unknown is how many petitions are going to be received and how many folks are actually going to get a number. So if you have a student that is still in school or is traveling and will meet the degree requirements at the time of filing, we do recommend that you actually put them into the registration and plan to submit an H-1B for them as many times as you can. I know that a lot of employers want to preserve the 3 years of STEM OPT, but in this day and age where everything is unknown, I think registering and trying to secure the H-1B will give more job security for the employee and then also for the employer to ensure that they actually can continue to work. So yes, we do recommend, even if the individual is not working for you, but they are eligible for the H-1B, that you do submit a registration and plan to submit a petition for them. Let's see. There's a question of what date do we know if, I think they got the H-1B petition. I'm not sure what that means, but in terms of registration, Once you submit the registration, you do get a confirmation on the portal that it has been registered. So you will get a number that it has been registered. And then they conduct a lottery, and then you will actually go into the portal and you will see a notification of selection in the portal, and then also a letter or some sort of notice that you need to file with the USCIS with the petition. Any changes to the process? The only, the petition process is the same in terms of the forms, the documents you normally submit. The only change that is happening is the registration process, and then also the reversal of the cap, the lottery, how the lottery is conducted. Again, general pool goes first with everybody, and then second, U.S. master's degree goes next. And then questions about filing within the 90-day window. You must file within the 90-day window. If there's a reason you're unable to file within the 90-day window, I don't know how much discretion the USCIS will give you if you file a nunc-pro-tunc. So it's extremely important that you actually file within that 90-day window and ensure that the petition's received within that 90-day window. Let's see. Oh, we got some accolades. This is well organized and very informative. Thank you so much. Can you watch this webinar again? Yes, if you go on to our WR YouTube channel, you can re-listen to Jennie and I again on this presentation. One question for you, Jennie, is it harder for consulting firms to get H-1Bs because of BAHA?
I'm sure it is, because they're going to make sure, they're going to really, you should expect an RFE on the employer-employee relationship unless it's really well documented up front, I think. So performance reviews, the offer letter, the pay stubs, showing how the consulting firm manages and controls the employee's work on a daily or weekly basis, and then having service contracts or work orders for the entire period, I think are probably going to be standard requirements for the initial filing.
Yeah, and then I think there's a misnomer here about registration and that it's simple. I think, the whole goal they thought and everyone thought was that registration would save time and money. Maybe in the future it will, but with this initial implementation, I feel that because of the unknown and the uncertainty, that we at WR are going to do as much as we can to ensure that these petitions are approvable, especially with BAHA. I don't think that we are doing our job at WR if we simply just take a bunch of names and then just register them into the portal. I think we need to do our due diligence as attorneys and ensure that the petitions that you come to us will be approvable. I think we have 1 more minute for questions. More questions about the portal. I recommend you just stay tuned to our site, stay tuned to the USCIS website, and you'll find out more information about what the portal looks like. Right now, if you go into the portal, myuscis.gov, and you create an account, there is a radio button for H-1B registration, but once you click it, it's a dead site. It's basically, it doesn't bring you anywhere. And that concludes our webinar. So again, you can rewatch this webinar on our YouTube channel, and we thank everybody who has joined in our webinar, and we hope you found it informative, and will contact WR for any needs you may have for immigration. Thank you.
Thank you.